Thank you for listening to Ingram Law. As always, we appreciate you being a guest. Our website is joeingramlaw.com. Our phone number is 205-335-2640. As always, we do take your questions off the air, and we will get back to you with an answer. This is Real Law Alabama, where we talk about law topics in the state, primarily criminal law and divorce law. If we take cases from Huntsville to Birmingham, Montgomery, and even Mobile. If you are in need of a divorce attorney, give us a call. If you need a child custody attorney, give us a call. If you are seeking to modify your divorce decree as to child custody, child support, or visitation, give us a call as well. If you are seeking a retained criminal attorney for your case and you want an experienced criminal lawyer, give us a call. We will talk to you first. We will screen your case. If we think we can help you, we'll get you to come in for a consult, and we will be glad to help you and represent you if we can. Tonight, we're going to talk about mediation in a divorce case and why it is so effective and why it's important and why sometimes this is the best way to settle your case. So you go and hire a divorce lawyer and you file a complaint, and let's say you have several issues. You have custody of your children. You have child support as an issue, visitation. Let's say you have considerable assets to divide. Maybe a marital home, maybe retirement accounts, maybe a lake home or rental property. Maybe sometimes you and your spouse own a business together. Maybe sometimes your spouse is the breadwinner and owns a business or a practice, is a physician in a practice group, is a lawyer in a law group or in a partnership, even an architect, even a dentist. And so you're wanting to get what your fair share would be from the divorce. So you have hired a lawyer. You have filed your complaint. Your spouse has hired a lawyer. Maybe me. Maybe I represent the other spouse in this case. And so we file an answer, and we will probably file a counterclaim if we are, disputing who should be the custodial parent and who's going to pay child support and visitation. We may be even having issues about who's going to take the marital home, division of retirement accounts, maybe who's going to take the lake house, or the condo at the beach, or rental property for that matter. Maybe the issue is my client owns a business, and we got to determine what the value of that business is, not just what it makes a year. My client may pay himself $75,000 a year. The evaluation of the business may say that business or that company's worth maybe $2 million over the next 10 to 20 years if it is a going concern. So those are all issues we have to look at. So we do discovery. For those of you that do not understand that terminology, discovery. You ask us questions under oath. We ask you questions under oath. You ask us to produce documents relevant to the marriage, pay stubs, tax returns, financial records, more present and relevant today than any other time. We may ask for your social media records, a copy of your Facebook page or your Twitter account or your Instagram, LinkedIn, whatever social media platform you may be on. And you may ask us for the same type of documents as well. Let's say my client owns a contracting business, and at the same time, he's done well over the last 15 to 20 years. He has built not just a contracting business, he's also built a building and supply store. Just follow me here. So he can buy the parts from his store and use them in his contracting business. There's nothing wrong with that. That means he has two businesses. He has a contracting business and he has a building and supply business. So really he's taken money out of his left pocket and he puts it in his right pocket when he makes a transaction. And let's say you represent the wife and your position is, well, not only is he a contractor making $500,000 a year, he's got a building and supply store that makes maybe $1.5 million a year. Maybe has inventory of let's say $250,000 in supplies. And so your position is that the building and contractor business is a $2 million business. Maybe we have to get a expert opinion to determine what the value of that business is. So we got a lot of issues in this scenario. So we've done discovery. We can't resolve any entered a schedule maybe from now. Let's say we've already done depositions. You've deposed my client. I have deposed your client. Hopefully we know what each side is going to say on the stand. And we are at a stalemate. Sometimes the court will have a status conference and ask the lawyers, where are we? We're either going to have a trial because we are at a stalemate on some issues, or maybe the court may order us to go to mediation. Sometimes the court can order mediation. Sometimes the parties can agree to go to mediation. So that's our topic tonight, mediation. It's a good thing. You can either have a private mediator, which is usually either a lawyer or a retired judge, which is a neutral third party to hear both sides. And the key word to mediation is called compromise. If you do not come into the mediation with the understanding that both sides are going to have to compromise on some issues, the mediation is not going to work. It's just not. So, okay, we've picked a mediator. Let's say for this topic tonight, we have decided to use a retired divorce judge that used to hear divorce cases every day, understands the issues thoroughly, can get to the heat of the matter really quick, and we get on the book, meaning his calendar, with the retired judge mediator. Sometimes the mediator will send you a letter, both sides. Thank you for choosing me to be your mediator. You do not have to do this, but you can write a position statement on the issues that are relevant. That will help me understand the issues before we sit down that day. And it'll tell me what your opening position and bid is in this case. And I always include, when I write a position statement, do not disclose this to the other side. This is confidential. And more times than not, if the other side writes a position statement, they will say, this is confidential. This is our position. Do not disclose our side or our opening bid with the other side. And the mediator understands that, and he abides by that. And when you go there that day, at least he has an understanding of where we start. So typically mediations will start 9, 10 o'clock in the morning. You go to a office. They will put me and my client in one conference room. The other spouse and their lawyer will go to another conference room. And the mediator will come in, introduce himself to the parties individually, say me and my client, the husband, the contractor who owns the plumbing business. And he'll say, I've worked with Joe. Joe's a good attorney. I want to set some ground rules for the mediation today. Mediation involves compromise. If you're not willing to compromise, this will be really short and sweet. You'll probably be out of here in less than 2 hours. If it looks like we're going to make some headway, then we'll just keep going. And we'll see if we can resolve all issues to save you litigation expense. The best part about mediation is you have some control over how your case is going to end. If you go to trial, a judge is going to solely decide the issues in your case. That judge may be favorable or unfavorable to your position on your issues. And so, mediator comes in. Joe, where do we start? Judge, this is what we want for custody. We think we should be the primary custodian based upon the income of the parties. Child support is set usually by the guidelines, unless they're over $30,000 a month. Then it's very discretionary and depending on their lifestyle. And this is what we think for visitation. This is what our position is on the house. This is our position on the retirement accounts. Maybe the lake house or the condo. And then this is what we think we should do with the business. Maybe we offer them a cash settlement as part of a property division settlement. And so they take our initial offer, They go across the hall to the other conference room. And when you got that many issues to discuss, you know, they're going to be gone at least 45 minutes, maybe an hour. And so you just sit there and wait. It's sort of like going to buy a car at a car dealership. Except here's the difference. When you go to a car dealership, generally they put you out in an open room so you feel very vulnerable. They have all the cards. They know what they paid for the car. They know the book value of the car. Their goal is to sell the car at the highest profit margin possible. And you feel like you're being taken advantage of. This is all very discreet in a conference room. And then maybe an hour later, the mediator comes back. Joe, here's where we are on custody. Here's where we are on child support, visitation, house. Maybe they have made some moves or some significant progress on some of the issues. Now, if we are at just a total stalemate on every issue, there's no point in paying the mediator to sit there and me say, I want this, and you say, I want that, and we can't agree on anything. Might as well hang it up, tell the court we mediated, can't reach a decision, judge, just going to have to try the case, you decide. But let's hope for our example tonight, we are making headway. And so we will work through the issues one by one till we can get through all the issues. I had a mediation about 2 weeks ago. We were there almost 9 hours. Wasn't a very complicated case. We did not have kids involved. It was primarily a division of marital assets, money, house, cars, tangible things. I always tell people, when you go to a mediation, you can divide $1. Half of a dollar is 50 cents. That's easy. When you go to a mediation over child custody, you can't split a child. Someone has to win, someone has to lose that argument, right? So it's hard to mediate custody. But if you can resolve as many issues as possible, then you can streamline your divorce trial. And you may say, Joe, why would I do that? Well, it saves you litigation costs. If you can go in and tell the judge, we've already decided about the house, we've decided about the retirement accounts, we've decided about the condo or the lake house. Judge, we've already reached all those decisions. The only one you've got to make today is maybe child custody and child support. That saves time, money, and effort and resources. So that is the benefit of doing a mediation, is that you can save money. Now, you do have to pay the mediator. Generally, each party pays half. Sometimes if you have the breadwinner or the spouse that makes more money, you can negotiate, and he'll probably pay all of the mediation cost. So those are all negotiable issues in a divorce mediation. So the takeaway tonight for you is that if you are going through a divorce and your lawyer says maybe we should try mediation, do not think that your lawyer is selling you out. your lawyer is looking out for your best interest, trying to give you some control over the issue still. And it may work out in your favor, and you can resolve the case. And the two of you reach an agreement on paper. The lawyers draw up the paperwork for the court. The court signs it, and you get a divorce. And you control some of the decisions in your life. So, we thank you for listening tonight. This is Real Law Alabama, Ingram Law LLC, joeingramlaw.com. Our phone number is 205-335-2640. We do take cases in divorce and criminal law from Huntsville to Birmingham, Montgomery, and even Mobile. If we can help you, please give us a call. We'll be glad to reach out to you. As we always say, take care of yourself and each other, and have a good night.
No representation is made that the quality of the legal services to be performed is greater than the quality of legal services performed by other lawyers.